Hello everyone, welcome back. We have our next installment in our crash course of American government for my IB history class. Today we are going to be taking a deep look at the judicial branch. We're going to take a look at not only the members of the judicial branch, their duties, but we'll also take a look at a number of landmark Supreme Court cases, many of which may appear on your test. So we'll go ahead and jump into the presentation at this time. All right, so starting with the Supreme Court. Well, I guess I need to back up. What is the purpose of the judicial branch? The purpose of the judicial branch is to interpret the law, right? So they do not write the law, they do not execute it, they are the interpreters of the law. Is the law in line with the Constitution? Has the law been violated by this set example, this event, this criminal action? They are the ones that interpret the laws and make judicial decisions. So the highest court in the land is, of course, the Supreme Court. It is one in which they decide both federal and also state laws. If they're constitutional, they can go before the Supreme Court as well. There are 9 justices that serve on the Supreme Court. The picture I have here is a little bit dated. 2 of those, one of those has been replaced since that time. So, anyways, a little bit dated there, but there are 9 justices. It is worthy of note that there have not always been 9 justices, and there does not have to be 9 justices. The Constitution does not define how many justices are used. I think it's been as low as 5 before, for basically a year and a half after Scalia died. I know the Senate basically held up the next nomination, so there were only 8 for about a year and a half there. But at times there's been 7. FDR had proposed packing it all the way up to 15, and got a lot of backlash for that, and rightfully so. But for the most part, it has been 9 justices. That seems to be a fairly good number. And there is a Chief Justice among them all, one that makes ultimately what you can consider the tie-breaking vote, I guess, but has the option of writing the opinion of the court in cases in which he or she sides with the prevailing opinion. Currently, that Chief Justice is sitting right there in the middle. His name is John Roberts. He was selected by George W. Bush. The next lower court, and kind of going down here in our kind of level of Supreme Court's the highest. The next level down would be the Court of Appeals. And it's exactly, I should mention the Supreme Court. It is not what they call a court of origination. Okay? There are no cases that start in the Supreme Court. They all have to start at a lower court and work their way up. I did not mention that, but I think that's worthy of note. The next court below Supreme Court is the Court of Appeals, and it's exactly what it sounds like when there has been an even lower court that has made a decision that one of the parties disagrees with. They can then appeal it, and it goes higher to this court. There are 13 total courts, appeals courts around the country. Each one of them has at least 3, sometimes more, justices, and they hear, again, I don't believe the Court of Appeals, it is not a court of origination, so meaning that the case that they are looking at would have to be started at a lower level. But they hear cases from lower courts, and they review whether the law that, judicial law was followed, or whether the decision was correct, whether it was based off actual evidence or not. So if, again, at the Court of Appeals level, if they decide to appeal their ruling, then it goes up to the Supreme Court. Okay. Now, going down the pyramid a little bit, we have district courts. And I think this graphic I have here is great. It shows you kind of how, not only where things can originate, but all the different types of court systems courts that we have in our system. So we're kind of at that lowest court there on the left, the federal district courts. And currently there are 94 district courts, and each one of them has some of them have just 1 justice. Others have, some of them have as high as 24 justices on those courts. But here is where you experience an ordinary court trial. This is where most federal cases actually begin. So if it's, a murder or something that has broken federal law, it will start at this level. but this is kind of the court of origination for most things that the Supreme Court would ultimately hear. Now, you do see on the other side there, kind of in the middle, we'll talk about those later. There is a state system of courts that we'll discuss when we're reviewing for our Missouri Constitution test. But you can see there that cases that begin at a state level can also end up in the Supreme Court. In fact, we're going to talk about a famous one that did today called Dred Scott, the Dred Scott case. So we'll come back to that later on. But this is kind of how the system is set up. So, most states have at least one district court, and that's where they really kind of it all begins. Now, one of the most important terms that you absolutely need to know for your test is what is called judicial review. Judicial review is the idea that the court can decide the constitutionality of laws, and it goes beyond that. They can actually reverse laws as well. But this idea that the court can decide that on their own, this is not something that was written in the Constitution. Okay, this is something that came later on in 1803 with Marbury versus Madison. In the opinion of that court case, they did decide that John Marshall actually established this idea that the judicial branch, as kind of one of their powers and duties, they do have the ability to declare laws unconstitutional. So very quickly, let's talk about that case, because that one very well may end up on the exam. And if anything, you need to know it for your next unit anyways. But Marbury versus Madison, 1803, and that is James Madison, who is being referred to there. What ends up happening here, Thomas Jefferson is president, and in 1800, he won the election and defeated the outgoing president, John Adams, who was a Federalist. Now, Adams had selected a number of people to fill official roles, and some of those had not yet gotten all their paperwork filed or had not officially been placed in those roles, even though they had been nominated and selected for those roles. Well, Marbury was one of these individuals who had been selected to be a judge. He had been appointed to be a judge by John Adams, but then the election happens, and Thomas Jefferson basically cleared house. He and Adams did not get along at all, and especially when it came to all of his officials that he put in place, basically cleared house, and Marbury was one of those. Now, what eventually involved this case was that Marbury sued under a law called the National Judiciary Act, which basically he believed would guarantee his job. The Supreme Court, they listened to the case, and they decided that law was in fact unconstitutional. Now, I believe they actually said that Marbury should get his job, that he was due that judgeship, but they, in this case, say that law was unconstitutional, that the legislative branch did not have the ability to pass that law. It did not fall in line with the Constitution. It extended their powers beyond what was reasonable. And so this established this idea that the courts were the ones to decide constitutionality and could strike down laws passed by the legislative branch. It's always kind of boggled my mind that was not included in the Constitution, because it's such a fundamental part of our system and fundamental part of the judicial branch, kind of one of the main things that they do. So anyways, Marbury versus Madison established judicial review, which allows for constitutionality. I'm not going to go much deeper into the kind of how it all forms. I feel like the judicial branch is one of the most straightforward branches, with your trials and whatnot. But we are going to talk about a number of Supreme Court cases, and some of these may appear on your exam. We're going to cover some very important ones. I think 10 total, maybe more than that. But let's start once again. Marbury versus Madison. I just covered all the details of that case. Established judicial review and allowed for the courts to declare laws unconstitutional. McCulloch versus Maryland. I mentioned this one in our lecture last time, and I should mention overall for each of these, I'll give you just a little bit of background of the story of kind of what led to the lawsuit, and then I'll tell you kind of the big thing that the court decided. All of these had ramifications for decades in the future up to the present. So a little bit of background, and then what the case decided. And again, 1819 McCulloch versus Maryland. This was regarding whether the federal government had the ability to was basically deciding which should supersede, federal law or state law. So the issue itself dealt with the national bank. The state of Maryland did not believe that the federal government had the power to issue a national bank, and in particular, all monetary notes that were being issued by this national bank had been subject to a tax in Maryland. And basically the federal government basically sued, saying that they were impeding kind of their ability to do business in Maryland. And it went all the way up to the Supreme Court. Supreme Court cites the necessary and proper clause, saying that a national bank can be established by the federal government because it is necessary and proper in order to collect taxes and do things like that. It is something that would fall under the elastic clause there. But the secondary and perhaps the more important issue is that they sided with the federal government over the state government, saying that federal law does supersede state law. So Maryland does not have the last say here. The federal government does. And that has major ramifications, especially considering that we're about 50 years away from the Civil War at this point, where states are going to be saying, we have the power to do whatever we want. And McCulloch versus Maryland is pointed to at that time, saying, no, you don't. Moving on, Dred Scott versus Sanford, perhaps the worst decision the Supreme Court has ever made. 1857, we're 4 years out from the Civil War, and if they had decided this case differently, I might be saying that differently, because this wholeheartedly inflamed the entire country. That really led to the Civil War. I mean, this was a major milestone in the steps leading to the Civil War. Well, let's talk about the background of this case. So what had happened was you had this issue between free states and slave states, right? Missouri was a slave state. Illinois was a free state. There was a slave named Dred Scott from Missouri, and his owner took him into a free state, into Illinois, and basically, what Dred Scott would sue for was saying that while he was in Illinois, he was a free man. But the problem was he decided to wait until he got back to Missouri to sue, and that was his downfall. Because basically Missouri Supreme Court says that yes, that is the law in Illinois, and frankly, they say if you had sued while you're in Illinois, you probably would have been free. But he waited until he was back in Missouri. In fact, I think this was years later. I think it may have actually been down in Louisiana where he officially sued. But no, I'm sorry. I take that back. I should have read up on this more. It was the Missouri Supreme Court. I do remember that. Missouri Supreme Court is the one to decide that Dred Scott would not be free. What's more important than just this individual's freedom was the ramifications for all slaves everywhere in the United States. Because what the court case ultimately decided was that Dred Scott would lose this case because he did not have what's called standing, because he was not a citizen. Now, Dred Scott had been born here. But he was not, basically the Supreme Court said he does not have the same rights and privileges as white people in this country, because he is not a citizen of this country. And that is really, what inflamed tensions, partly because, this would be rectified with the Civil War amendments later on, when dealing with things like citizenship. But it went even went even beyond just that issue. What the Supreme Court justice at the time went on to say was that the Missouri Compromise, and I know we haven't covered this yet, but that the Missouri Compromise was unconstitutional, which the Missouri Compromise wasn't really a part of this. He had backed up to the point where we were deciding whether Missouri should be a slave state. And basically there's this compromise where Missouri was added and Maine was added as a free state to keep the balance. Well, the judge in the Dred Scott case said that the Missouri Compromise was unconstitutional, meaning that Congress could not stop slavery, could not ban slavery in the territories. This is wrong on so many levels. Going back, I talked about the Northwest Ordinance, Northwest Territories. That right there, that alone proved that the government had or at least the founders had this idea that slavery could be limited. What the judge in Dred Scott was saying was that Congress doesn't have the authority to limit slavery anywhere. And that's really what inflamed tensions throughout the country. So it's it's a very, very deep case, not only, of course, sadly for Dred Scott himself, but for the ramifications for slaves everywhere. But, also the fact that he's declared not a citizen, that has a lot of ramifications. But ultimately, the Missouri Compromise is overturned, meaning that future territories it was up in the air. Before it was denied. If anything north of a certain line was going to be free. That's what the Missouri Compromise said. And this overturns that, which really inflamed tensions in the North in particular. We're going to talk more about that in detail later on, but hopefully you're able to follow along with my rambling there. I apologize. All right, fast forward 1896. Man, I got a lot of bad decisions on here. Sadly, those are the ones we remember the most. 1896, I'll start with kind of what this established. This is really what legalized segregation in this country. And for the most part, this is the beginning, or at least the legal beginning of Jim Crow in the Jim Crow era. So, legalized segregation throughout the country. And this really, it set our nation back literally decades. It would not be until Civil Rights Act of 1864 or 1964 that we would undo a lot of this ruling. But let's talk about what got us there. So 1896, Plessy versus Ferguson. Basically, the case that developed, it happened in New Orleans. You had a man named Homer Plessy who was 1/8 African American. He was very fair-skinned, and I should mention that Homer Plessy was working with civil rights groups there. I believe it was the NAACP. This was not necessarily just a spur-of-the-moment thing. This was a somewhat planned event. But they were seeking to challenge the segregation laws in New Orleans. And so they sent Homer Plessy on board a train. And at the time, train cars were segregated. They had whites, and the term that was used at the time was the colored section. So Homer was told, he sat down in the whites-only section and was told by the conductor, basically, you got to move to the colored section of the car. And he refused. And if this sounds familiar, it should sound familiar. This is the exact same story of what happens with Rosa Parks, but with a much, much different ending at the Supreme Court level. Homer Plessy is arrested, and that gives him basically standing to sue not only the railroad company, but the state for having these segregation laws. It goes all the way up to the Supreme Court in 1896. They decide against Homer Plessy. And the biggest thing you need to know about this, the legal ruling, they say that that the train company was within their rights as a company to deny him the ability to sit here because they had provided a separate but equal facility. All right, let me say it again, a separate but equal facility. Because the railroad company had provided true train cars that were in all purposes the exact same, okay, separate but equal, that they were allowed to have that. It was their choice. That ruling would be applied to everything. So now, as long as you have separate but equal schools, water fountains, the list goes on and on. This is what legalizes segregation in this country. Segregation had happened decades before, and I want to mention that, but neither side had really pressed the issue in the courts because they were afraid of, the law falling against their side. So 1896, man, really set our country back in a lot of ways. And I'm actually going to mention this one again when I get down to Brown versus Board of Education. Number 5, Korematsu versus the United States, 1944. Another disappointing ruling. This happens towards the tail end of World War II and is specifically about the United States government's role in arresting and creating internment camps for Japanese American citizens during World War II. Excuse me. In 1941, when Pearl Harbor was bombed, there was a wave of fear that struck this nation. And I think this is one of the greatest lessons I can teach you guys, is that when we as a people become afraid, we often violate the rights of ourselves or others as a result. we often act irrationally when we are fearful, and that is the case here. With the attack on Pearl Harbor, there was a fear that the Japanese would continue their attacks eastward and would eventually land in the West Coast and attack, California or Washington, Oregon. And so FDR, in something, I think overall FDR was a good president, but man, this was by far his worst decision as president. Just absolutely terrible and racist. I mean, there's no way around this. There's a series of executive orders, but one in particular is signed by FDR, which allows for the internment of Japanese Americans in the United States. What makes this so sad is not only do we become a lot of kind of like what we're fighting against. I mean, we literally set up concentration camps around the country. Now, I will say they're not death camps. They were not, and not to excuse them, walking a very fine line here. They were internment camps where these people were arrested and placed, and I will say the conditions were not the best. But they are not death camps. Do not equate them to what we see in the Holocaust. But you better believe that they were internment camps that were holding American citizens that had been arrested because of their race. There's no way around saying that. That is exactly what happened. This executive order allowed for the roundup of all Japanese Americans in the West Coast, and it actually allowed for the roundup of Italian and German citizens elsewhere as well. There were arrests made for those other ethnicities, but much lower in number, less than 500, I think. When we're talking about Japanese Americans, it was in the thousands. Now, this ruling would go all the way up to the Supreme Court, and this young man Korematsu had his day in court and was able to challenge it. But the Supreme Court, I think somewhat shockingly perhaps, said that the United States was within their rights, given the fact this was an emergency situation, that in this case, that this fell under FDR's wartime powers, which does allow him to limit the rights and freedoms of individuals. Basically, it goes back to kind of that first lecture I had, where the government has this very difficult job of maintaining a balance between security and liberty, security and freedom. And at times that balance is skewed one way or another. And in times of panic and threat, there are individual rights taken away. And I would always argue against those, but the Supreme Court sided with the government in this case and said that FDR had the ability to have these concentration camps because the threat of Japanese espionage outweighed individual freedoms in this case. I would like to note that there was not a single person found within these groups that were taken to be a Japanese spy. Not one. For the most part, the Japanese American population along the West Coast was extremely loyal to the United States. You just didn't have the threat there, but there was the fear, and there was a fear that they weren't American enough, perhaps. It's a very sad moment in the history of the United States. And I do want to note that it has since been recognized as an error in judgment. In fact, President Reagan in the 1980s issued not just an apology, but there were actually reparations paid to the families of those interned in the internment camps. So this was something that later on, decades later, everyone kind of realized this is the wrong thing to do. And so frankly, kind of scary stuff when we talk about the government setting up what amount to concentration camps. Man, it's difficult to even discuss. Moving on, number 6. Finally a good one. Finally a positive one. I've been nothing but negative so far. 1954, we got Brown versus Board of Education. Man, this is really when things start to change for the better in terms of civil rights in this country. Again, the background for the case, for those of you listening in Kansas City, the case doesn't take too far away from here. It's just a few dozen miles over in Topeka, Kansas. That is where this case originated. Topeka, like most cities in the United States, was segregated, and they had a white school and a black school. And by the way, I should mention, back to Plessy versus Ferguson, that whole separate but equal thing is bogus, right? Just think about how, just even after a year, even in this hypothetical scenario where you built two schools, one for white kids, one for black kids, and you made them the exact same school, okay? It's still different, right? It's still not equal because you're being told you have to go to that school because you are black. Right? It's an unequal experience, and that's basically what the court is going to decide. But in reality, logistically, of course they were not equal. I mean, every black school in the country received less funding, less funding for teachers, secondhand textbooks. It was never equal. And so, anyways, very frustrating. But the Brown versus Board of Education ruling, a number of families in Topeka, Kansas sued, saying that they were not getting equal representation. In fact, the main family that's labeled here, Linda Brown, and her family, I think she was 9 years old at the time. She was quite young, but they actually sued, saying that by forcing her to go to the African American school, that it was actually putting her in danger because it was farther away. She actually had to cross town, had to cross railroad tracks in order to go to the school, where she could have safely gone to the white school. And that did help sway the court a little bit. It was not equal. It was definitely separate, but not equal. So Brown versus Board of Education, finally a good ruling, which basically cuts down segregation. It does declare segregation in schools to be unconstitutional. Now, this does not end segregation. In fact, it would be another decade before segregation would legally come to an end. But this ended segregation in schools, at least in the letter of the law. In reality, as you can imagine, southern states did not take well to this, and many of them would struggle to integrate their schools, and some just flat out refused, like Arkansas. They just flat out refused. In fact, would have to get the President of the United States, Eisenhower, is going to have to send in the National Guard to force these schools to allow black children to attend. Sad moment for our history, but one in which we can be proud that the system actually works. More specifically, just looking at my notes here, they specifically said that in Brown versus Board of Education that segregation did violate the Equal Protection Clause of the 14th Amendment, that regardless of race, people need to have equal protection in the eyes of the law, and segregation, of course, does not do that. All right, moving on, and this is the last page we're going to be covering. My time, I'm getting up there again. I apologize, these are longer, but remember, you are avoiding an entire semester worth of American government for these few lectures, so there's a lot of information to cover. Number 7, Matt versus Ohio. This is an interesting case, 1961. At this point, the case began when a woman got a knock on her door in the state of Ohio, and police officers basically barged in. They did not have a warrant. They were in search of, they were looking for a subject. They did not have a warrant to come into this woman's home. And while they were in her home, they found some illegal material, specifically pornography, which at this time was illegal, and they arrested her for that. So they entered without a warrant, and they arrested her for this illegal material she had in her home. She sued, saying that it violated the law, that this was an illegal search and seizure, and the court agreed. In Matt versus Ohio, they said that evidence found through illegal searches is not admissible in court. So if the cops break the law by coming in without a warrant, anything they find in there, they cannot use to hold again. So that's, this does hold police accountable, or at least it's supposed to, about, making sure that they are following the letter of the law, to make sure that rights aren't being violated. So Matt versus Ohio, again, evidence through illegal searches is inadmissible in court. Number 8, Gideon versus Wainwright, a couple years later, 1960s. Hey, a lot of these we're getting into individual rights. If you study Supreme Court cases, you'll notice that there's definitely themes that emerge with different cases, different courts. The 1960s was heavily focused on the civil rights, and so you see a lot of individual right cases come before the court. In this one, Gideon versus Wainwright, Gideon was accused of a crime and was frankly very poor and was unable to afford his own counsel, and was basically denied counsel in the courtroom. And that was found to violate Gideon's rights because, part of what the Constitution or the Bill of Rights protects is due process. And if you do not have the ability to defend yourself in the court of law, that is not fulfilling due process. So Gideon versus Wainwright protected due process and basically reaffirmed the right of the accused to have counsel in the court of law. Number 9 is Miranda versus Arizona. You're probably familiar with this one, or at least as the result. The case here, Miranda, I will say, not a good person. Miranda had been convicted of kidnapping, rape, and had confessed to that. The problem was that basically Miranda was able to prove that it had been kind of coerced because he was not sure of his rights. He did not have his rights told to him and did not know that he had the right to counsel or the right to remain silent. And so had basically confessed to these crimes and sued, saying did not know that he had the right to counsel and would have pursued that if had been the case. So this is what establishes the so-called Miranda rights. Whenever someone is arrested, they are read a series of rights that they have. Right to an attorney, right to remain silent, things like that. Number 10, Tinker versus Des Moines. This is an interesting one involving students. 1969, that's the heart of the Vietnam War. Tinker was one of multiple students in Iowa that had worn a black armband to class as a silent protest against the Vietnam War, just simply a black armband. The teacher had declared that it was a distraction to other students, and the principal had agreed. They had suspended Tinker for wearing the armband, and they sued, saying that this was a violation of their freedom of speech, that it had not caused a distraction, as the teacher had suggested, and that this was a mild form of protest and that it should have been allowed in school. And the Supreme Court sided with Tinker on this one and said that, this was, a black armband was not an unreasonable thing to allow, and that it was seen as an example of freedom of expression, freedom of speech, and that it should be allowed in schools. 1973. Perhaps there's not a more divisive case over the last 50 years than Roe versus Wade, in which you had a young woman challenge the illegality of abortion, and saying that a woman should have the right to do with her body in cases of an unwanted pregnancy, and that the state making abortion illegal was a violation of the right to privacy, of within one's own body to decide the fate of one's own body, and that right of privacy being somewhat outlined, doesn't specifically say right to privacy, but the 9th Amendment. And the Supreme Court, I think it was a 5-4 decision. It was very close, very debatable. They ultimately did side with this woman in the case that legalized abortion throughout the country, and very contested ever since. And frankly, it comes up every time we have a Supreme Court justice. What is your view on Roe versus Wade? And they're trying to figure out, whether it's somebody who would want to reverse that case. As we've seen in judicial review, that can happen. And I'm thinking judicial review, I'm sorry, I didn't mention it. Brown versus Board of Education. It reversed Plessy versus Ferguson. Sorry, I'm going backwards here. I did not mention that, though. Brown versus Board of Education showed a power of the courts, and it reversed Plessy versus Ferguson. And in fact, it actually went in and they used the exact same language. Plessy versus Ferguson said separate but equal. Brown versus Board of Education said that separate is inherently unequal. All right, boom. All right, anyways. Number 12, Texas versus Johnson, 1989. This is another tough pill to swallow for a lot of people. But in this case, you had Johnson. This man was arrested for He was on his own property in his driveway, and he had burned, as a symbol of expression, freedom of speech, had burned an American flag as a symbol of protest. That was illegal, according to the state of Texas, and so he was arrested. The case went all the way up to the Supreme Court, and the Supreme Court basically said that while he was burning a symbol of what gave him the right to even sue in this case, that he did in fact have the right. It was a reasonable right. It did fall under protection of freedom of speech to burn the flag. May not be a moral choice, but it did fall under that banner of freedom of expression. That's a tough one. I mean, you would like to think. I don't know. I'm not going to go into that one, but it's definitely one that people, I think, kind of came out against, saying, that just seems so backwards that we would allow the flag to be burned as a freedom of expression. But in this case, the Supreme Court decided that it's better to protect those freedoms, even if they disagreed with how those freedoms were being used. It was better to protect them. And then finally 13, and man, this was a doozy. This one has really altered the course of history. In 2000, and this was the first election that I really felt like I was kind of a part of, really understood what was going on, really was paying intently to. But in 2000, you had the Republican nominee, George W. Bush, who had been governor of Texas, versus Al Gore, who had been vice president under Clinton. And the two men went at it. We knew it was going to be a close election. It truly was a close election, and really all came down to Florida. The states were completely divided. It came down to what Florida was going to do with their numerous votes. And it was so close within Florida that multiple recounts were being called, and in some cases automatically triggered, but were being sued for by both sides. And the case, basically after the last recount, the Bush team sued to stop the recount, saying that there had been a number, this basically had to stop at some point. And once again, in a 5-4 decision, the Supreme Court, being placed in a position, frankly, they never should have been placed in, did side with the Bush team. And it's worth mentioning that you don't want to think that Supreme Court justices are partisan, but this was a majority conservative Supreme Court, and it has a bad look that they did side with the conservative politician here. But ultimately, they stopped the recounts in Florida. Florida was given to George W. Bush, and that gave him the election. Even though Gore had won the popular vote, Bush getting Florida did win him the election. Man, it was a tough pill for America to swallow, and frankly, it was a very divisive moment. It would be overshadowed over the next, frankly, year. Once 9/11 occurred, people kind of forgot about this, but it was just a tough moment. Especially, you can tell, 5-4 decisions. It means that there's a real question there. It's not very clear for the justices, but basically they decided the President of the United States in that scenario by stopping those recounts. So I don't know what would have been better. I don't know that how long the recount should have continued. I don't know, but you can very, very much say that they helped decide the President of the United States in 2000. All right, guys, that'll do it for the judicial branch and the landmark cases. You need to know at least kind of the results of those cases, not necessarily the background, but the results, of those cases. We only have one lecture left, and we're just going to be wrapping up some additional topics that didn't come up in the actual Constitution, some civic duties and things like that. So we will wrap it all up next time, and thanks for watching.